So happy to be here at the virtual Unicode conference, and thank you for being here in my talk after the keynote. We're pre-recording today and we will be answering questions online during the conference. Privacy has changed a lot in the last 20 years and way more during the last 6 months. When COVID hit, people had to shelter in place and the whole world became virtual. We have seen the fastest quantum leap in the use of technology since the cell phone, in education, telemedicine, medical research, work from home, etc. In this new world, sometimes it feels like privacy has gone out the window. We must remember privacy is a fundamental right, and we need to strive to protect personal data. In this virtual environment, we will work on making this presentation engaging. Some ground rules. Please use the chat to ask questions. I will try to respond or follow up after the conference. Second, I will ask questions during the talk to make sure that you're paying attention. The first person to respond correctly will get a gift after the conference. Lastly, even though we're not meeting in person, please feel free to network with me during and after the conference. We are all on this together. For those of you who don't know me, I have been working on internationalization for a few years now in large and small companies. A few years back, when I was at Adobe, I led the development of the first initiative to capture users' data. And at Microsoft, Trustworthy Computer was always part of the functional specs. But it was until I started working with startups and I began to work more on international privacy and payments. There is so much to learn. However, this is a subject that is close to internationalization, and I really have become a privacy enthusiast. I'm an engineer. I'm not a lawyer. You must consult with legal experts for all details regarding global privacy laws. Disclaimer, legal information is not legal advice. Yes, raise your hand if you accept. Thank you. Let's get started. Today we will cover the current global privacy regulations, what was changed since COVID in privacy, and we will cover what is GDPR, CCPA, and other regulations. We will review what actions in internationalization and localization need to take, as well as a case study of a company I consulted with. We will not cover internationalization infrastructure, and I assume by this time you are aware of the basics. Then who has not heard about GDPR? If you have not, you have been living under a rock. Data privacy is not new. GDPR is an expansion of existing privacy laws. Today, we will cover the general data privacy regulation and privacy regulations we need to be aware of. Some background. If you live in a first world country, most likely the moment you were born, there is an electronic record of your birth. Many parents secure .com names and email addresses for their unborn children to secure their digital identity. In this new open social world, you would expect privacy is no longer relevant. However, due to the increased accessibility of information at some point during this process, companies figured out that they could make money off your digital identity and started to create ways to capture everything about you. Your name, age, location, language preferences, etc. To a point that where there was no choice for privacy anymore. There were early attempts by governments to set guidelines about privacy. One of the attempts to regulate privacy was started by the European Union with GDPR, or General Data Protection Regulation, and many countries have followed to protect individuals' data. In the scope of internationalization, globalization, localization, and marketization, privacy is present at every level. To support privacy, you need to enable to detect location, process local data, and localize text according to each market and regulation. Then why are we here? You get a request from a user in California that requires to delete their personal information. Or imagine that there has been a security breach in your company, personal identifiable information was stolen from your customers in Europe, and you need to respond within 72 hours. Or you get a notification for an audit to ensure that you are complying with privacy regulations in Brazil. This is a warm-up question. Please use the chat to respond. There's no gift for this one. Can you handle these situations? Can you handle that you can respond within 72 hours? Can you handle that data has been stolen or there has been a breach or that a user requests to delete their data? Just type on the chat, yes, 1 for yes, 2 for no, still working on 3, not at all, I need help. Then if you're not prepared to handle these situations, you're not alone. Almost a year and a half later, after GDPR became in effect, companies were still struggling to comply with it. And today, almost half of the companies are not compliant. And this is a self-reported figure. The challenge is that you may think that you're compliant, but in reality, you are not. It does take a lot of effort to implement GDPR and privacy end-to-end. As many of you know, global privacy regulations is expanding. They go from countries not having any rules to pending to being restrictive and most restrictive. Russia, for example, had enacted privacy laws as far back as 2005. And some of you may have heard about LGPD and the new privacy law in Brazil and CCPA that is still evolving. Then first things first, before we start, let's review some basic concepts because privacy has its own language, just like internationalization. We need to walk before we can run. Then we'll go over some of the basic privacy concepts before we dive into the regulations. Data principles, consent, individual rights, location, personal data versus personal information. Then let's start our tour of the privacy principles that are shared around the world, and many of the times the differences are around the scope, clarity, and the definition of subject and access. Then legality. You must process all user data for a specific purpose, clearly and truthfully stated and agreed by the user. The purpose limitations. The reason you are collecting the data has to have a legitimate purpose. Data minimization. You must need to limit the amount of data that you are collecting. Data accuracy and quality. Ensure all the data you stored is accurate and up to date and accessible. Storage limitations. Only keep data you need. If you no longer need the data, use a pseudonym to protect user identities. Integrity and accountability. You must protect user data against unlawful processing and loss. Encryption and privacy by design are required. Central to all privacy regulations is consent. We have all seen the cookie dialog. This is the first and foremost one of the most important aspects of the new regulations. We need to ensure there is an explicit, and this is with capital letters, explicit consent of the use of the data. The wording and the explicit consent as well as the options need to be customized depending on the country regulations. Then write that down. Consent forms a contract between the provider and the data subject, and I will explain a little bit what that means, or the user, or how the data will be kept. This is an invisible handshake. What are the individual rights of the data subject or of the user? Then provide transparency. Users need to be informed on how the data is being collected, stored, managed, protected, and processed. Provide individuals with access to their data and explain how they or any supplemental data are used. Provide copies of all stored data in a portable format. They should be able to take their data with them if they need to. Comply with requests not to automate decision making using personal data. Correct any personal data if incomplete or inaccurate. Remove personal data on request. An oral request not to process an individual data for specific purposes, and allow individual data to be stored but not processed. Then there is a lot of moving points here when you're handling to be able to comply with the individual rights. Another basic aspect of data is data location. Like, do you actually know where all the user's data is in this global environment? The data can be sitting in a filing cabinet somewhere. It can be in a server somewhere else. It can be on the cloud. It can be on somebody's drive in their personal computer. It could be in GitHub. Then knowing where the data is stored is extremely critical. And then what's the difference between the personal data and personal information? Then personal data is any piece of information that someone can use to identify with some degree of accuracy a living person. Personal data may be named, but there are many people that share that. Then when a piece of personal data is added with other pieces of personal data, it becomes personal information. Then that is the difference. Then question. Then use the chat to answer this question. Whoever answers correctly first will get a gift after. Then give 3 examples of global privacy principles. I'm going to give you like 20 seconds to write. You can continue writing after this. Then now let's go and talk about some examples for global privacy laws. Then privacy laws around the world are many. There's about almost like 100 countries that have enacted new privacy laws just in the last few years. And each one have separate legal frameworks with different scopes, definitions, and requirements. Then this becomes very complicated to manage. But, as we mentioned, there are some global general principles. And if you align with those, you're going to cover most of them, but you do have to understand the differences. Then GDPR is one of the main ones. And at least you need to understand in a nutshell what it is. Then, as I mentioned, the GDPR is not new. What is new is that the EU Protection Directive was expanded to provide further privacy and security protection to users' data. And it is the most important change in 20 years. And it started to be enforced in May 2018. And unfortunately, not compliance comes with hefty fines, up to 20 million euros. Then, some of the changes include the territorial scope, the penalties and the use of consent, and the broader definition of the scope of the personal identifiable information, as well as the data subject rights. Then we talked about California Consumer Privacy Act, CCPA. Then the CCPA grants new rights to the consumers, rights to know your data, delete, opt out, opt in, consent for minors, and non-discrimination. Provides notice, create procedures to respond to users' requests, verified identity of consumers, and maintains records of requests. Then the CCPA needs a minimum threshold of annual gross revenue of 25 million. Big data is a commodity, and basically is trying to protect, the use of this personal identifiable information. And something that you should know, basically it's in effect it was supposed to be in effect on January 1st. It was postponed because of a lack of resources to enforce it, and then because of COVID. But because during this time there has been a lot of lobbying about changing the regulations, and now there is a new effort to basically create a new privacy law that will close the gaps that now the CCPA has. Then the CCPA, it's very much like the GDPR, but it does have some additional requirements that you need to be aware of. And for all, and I mean for all California residents, and we are basically between 30 and 40 million, then it applies to us and we need to be aware of it. One of the most important requirements for CCPA is this ability that do not sell my personal information. And I'm sure that you have seen this. Many of the companies have already implemented this dialogue, and if you have not, definitely put it on your to-do list. This is something that must have happened, and this is for CCPA only. And the other big is to delete all your personal information. Then what about the rest of the world? The Asia Pacific Economic Cooperation, APEC, includes 21 countries. The APEC Privacy Framework lays out 9 principles that are very similar to the ones that we mentioned before. The only thing about this framework is that it's mostly guidelines. Then that is one of the weaknesses. But what is happening is that many of these countries have used this framework on top of the GDPR and the CCPA and created their own guidelines. And this is something that you can see, for example, in Mexico, where basically they have created, data laws that are relatively strong, especially compared to the rest of the APEC countries. But the laws differ somewhat from the US privacy laws and the UA data initiatives. Then if you have data stored in Mexico or have plans to transfer data in Mexico, you should consult with an expert internet attorney to make sure that you receive the full protection of the Mexican laws. And then who's not doing business with Brazil? What about Brazil? Then this is one of the laws that you need to be aware of if you are basically collecting or processing personal data in Brazil, or you have individuals located in Brazil, or you you have customers from Brazil. Then the LGPD was coming up actually in October, but because of COVID, it has been postponed to next year. And some of the basics have not changed, but basically, it also has a lot of fines and a very short period to respond. You have like 15 minutes to respond in case something happens. And just as a footnote, as a quick footnote, all these regulations, all these global regulations, most of them apply to nonprofits as well. Then if you are working in a nonprofit, you are going to have to be able to abide as much as possible to these privacy laws. All right, then time for questions. Then give one example in which CCPA differs from GDPR. Then write it in the chat and you can get a gift after the conference. This is just for the first person who responds, not for everybody. Then try to be quick. Or if you just want to answer to show off that you know what you are, that you learned something, that will be also fine. That's your prize. Okay, then how do we enable? Let's talk about world readiness for privacy. Then a couple of years ago, I designed a global privacy maturity model. Then this is my design. Then, early in the process, it's the companies are market agnostic, the products are market agnostic. The data is all over the place. They more or less feel that they have a little bit of regulation awareness, but they know that there's GDPR over there, but they haven't really been doing much. The tier one, maybe they just put out there, a consent just to feel good that they're doing something. Maybe they started to look at the storage and the processing response just for the tier one markets, and they may have some tier one, business processes, and they just have a very, very light market risks. Then they start to develop, and they start to go deeper into supporting each one of the regulations. They start to be more aware, and they start to put resources into enabling privacy in their tier one markets. And then, finally, they're compliant. They have a nice global privacy framework. They have market-driven consent, storage, response. They have a global compliance database. The risk management is more mature. They have a team in place, and so on. Then, you move. This is something that doesn't happen at once. It is a multi-year process, but you have to have some type of a roadmap on how you're going to get there. And this is an example of how you can actually make it happen. And, we talked about having some type of a dialogue just to get started. And, many times you have seen this cookie monster, right? Then this dialogue is letting you know that the app or site is using the cookies and that you agree with this practice. The impact to the international team and the company is more than the localization of the cookie dialogue. As we saw in the privacy by default parameters should be marketized. Then this one is not necessarily a good example of what you need to do. I will give you a very good example in the upcoming case study. Then this one is a little bit better. It allows you to accept and allows you to learn more about cookies. But anyway, then how do we do this market localization of this cookie dialog? We have talked about the market-driven business rules. The same concept applies to the localized content. Because the nature of the content, it is imperative that the localization is reviewed by local legal privacy experts, not only localization and translators, because there is a lot of language and a lot of local regulations that you need to be aware of. Then from the localized consent of the cookie dialog to the privacy terms of service to the notification that will be sent to the customers in case of breach. You need to ensure everything meets the local privacy regulations. And then what about localized user consent? Consent must be a positive action. And what that means is that an individual has to click on something along the lines of, yes, I agree. An individual that does not respond to a marketing attempt cannot be said to give their consent by an absence of an action. Then these companies that are saying, oh, if you continue to use the site without clicking, you accept, that is no. Very few companies are currently complying with these regulations and are not complying with these regulations, and this is not right. Then make sure that your consent dialog it's appropriate. Then let's talk about the localized of the privacy and terms of services. Then when dealing with the global translation, this is important to note that other countries have completely different legal systems. Then the terms and processes may be similar, but there are striking differences. All words in legal documents are deliberate and could have different meanings depending on culture. then a professional translator will take this into account and make certain to provide a document that is not only legally correct, but understandable. And this needs to be reviewed by a lawyer to meet the local law. Then let's talk about the market-driven implementation of privacy. Then from the cookies to the IP address to the EU Privacy Shield, then local aware PII, financial health, user tracking, and others. The user interface needs to allow to withdraw consent, data deletion, and agreement, and data export. All the data needs to be local aware, from collecting, processing, storing, access, and deletion. And then, from now that we have localized the product and we have enabled and making it local aware, this is not enough. On the business side, then there must be market-driven business processes implemented along the way. Then the international team needs to work closely with the other parts of the company to support these business processes. And this includes privacy by design, global privacy business rules, compliance database, audits, and impact assessment. And let's talk very quickly about the first business process, that is privacy by design. Then privacy by design is a framework. This is a standard framework that exists. Then proactively embedding privacy into the design and operation of the product. Lead with privacy as the default setting. Ensure that the privacy by default means that when a system includes choices for the individual on how much personal data he or she shares with others, the default settings should be the most privacy-friendly ones. And this is just some examples of the overall privacy by design. And then establish what are the global compliance business rules. We need to know, this we're talking about now like 100 countries that have different privacy regulations. Then needs to be local aware, needs to be, you need to be ensuring how you're going to be storing and managing the data, that you are going to provide choices through the preferences, what is going to be the time frame that is going to vary from country to country, and how you're going to be using the data. Then these business rules are very much aligned with the principles, the privacy principles that we talked about at the beginning of the talk. And the third is establishment of the global compliance database. Then your global compliance database hosts the global regulations to meet the international standards for data privacy, and must include the discover, manage, protect, and report for all the data. And all the functional areas across the company need to be plugged into this global compliance database, need to be able to access that. And as you can see here on the right, I put the TMS because, everything will have to be localized and enabled. And the fourth business process is the audit preparedness. And, many of these regulations are going to be requesting that you provide where you are in enabling of your privacy support. Then you need to understand through a gap analysis. It's like where you are now and where do you want to go and what are you going to do to close these gaps. And this is going to be, again, a multi-year effort, but it's very important to understand where you are. Remember when I was asking you, like, what if you were able to respond to any of the use cases that I mentioned at the beginning? And some of you may have mentioned, it's like, no, I need help, I don't have any idea where to start. Then this is part of the process, is being aware of where you're missing out. And then lastly is the impact assessment. And is there a clear understanding of the roles and responsibilities in case there is a breach or request? And in many cases, the law requires to respond within 72 hours. And this is the what, when, who, and how, and who's going to be responding, in what language, to what regulation, then this is absolutely critical. Then now that we covered the business processes, then in the chat, the question is, what are the 2 business processes to enable a global product for privacy? Then take a minute, write on the chat. You'll get a gift after the talk. All right, then this is my famous case study. I like this case study because everybody knows what CRM is, and I don't have to explain it. But in this case, this company was a mini version of Salesforce, focusing on supporting a small company. And the reason I like this one, this case, is because it's like everything you wanted for like an MVP. Multi-platform, web app, website, mobile app, more than 50,000 users. The customer data included profile, usage, customer support, and payments. Hello. Markets organically grown, mostly in the EU. And there was some INTN and L10N infrastructure like data, location, language. But the privacy compliance, it was very early. They were market agnostic. Their data was all over the place. They understood that the GDPR was coming, but they had nothing implemented. And one of the things that we did was to basically set up a framework based on privacy. Then this is the privacy framework that we did for this particular company, based on regulation. I think about GDPR, and the GDPR applies to many different countries, and then some countries have different languages. And then you may have the regulation like the CCPA, and then the country is the United States, but the state is California, and there are many states in the United States which have their own privacy laws, and you have to be aware of those. Then the requirements, the customer, we needed to respond to a GDPR request. Then our strategy was to address the GDPR requirements, and the locals and markets were in English markets, and tier 1 including the EU languages. Then this is how we went about it. We talked about the data audit that basically identifies the gaps, then target the compliance, then we did some training, and then we basically involved all the different partners in the company, like legal and localization and so on. And then we built the privacy into the product, into the INTNN and then LTNN. And then we did the PO market-based use cases that are consent, access, deletion, notification, and others. And then working at the same time, ensuring that there was a clear understanding of the business rules and ownership. Then we talked about having a much better dialogue, right? Then you have a market-based consent instead of like a generic consent like what we had before. And then we were very specific about how the data will be used, by who and for how long, and the ability to basically access the data, delete the data, or withdraw the consent. Then this is a much better dialogue, and as you can see, there is a very explicit button here that says, I don't accept. Then this is my recommendation about how to implement your privacy dialogue. And I want to give you a couple of those user stories. One of user stories for GDPR, and is about the user should be able to delete data. Then as an existing user in the EU, I need to delete my personal data. I need to be able to access, to contact, inform, and I need to understand how much time we have to respond, who is on point, what is the impact, how are we going to solve this? Then we just need to ensure that all our data subjects, all our users, communications are in normal natural language and are localized in their language. Then that's a user story for GDPR. Then let's do a user story for CCPA. A user should be able to select, do not sell my personal information. Then this I mentioned, this is one of the first user stories that you need to focus on. As a California resident, I need to be able to choose not to sell my personal information. Then, you need targeting cookies and the strictly necessary cookies, and then just ensure that you have a plan for CCPA. Then let's talk a little bit about the INT9 infrastructure. All of you, I mentioned that all of you should be aware of this, but it's basically ensuring that the ensuring that the data is local aware, that local aware dates and times, because the data has to reside in the database for X amount of time. There has to be a local aware processes, market-based localization, and market-based business rules. And today we covered what was GDPR, CCPA, how other countries' regulations are evolving, how to get ready for world-ready privacy, and we also covered, a mini case study. Then we cover some of the best practices for you to take away, and you need to understand what risks are you taking of not doing anything. You need to stay updated because this is changing continuously. The privacy landscape is constantly evolving. And then one best practice is always to implement beyond the regulation and what the user expects, because you never know how things are going to change. Then thank you so much for attending my presentation, and I very much hope that you enjoy the rest of the conference. Then one last question. Then what are two examples of GDPR and CCPA use cases? Then this should be surely ready in your mind, and just the first one gets a prize. Then please type your questions in the chat, and I will try to get back to you during the conference or after the conference, or you can always connect with me on LinkedIn. And thank you so much for attending my talk, and stay safe. Thank you.